an emergency motion because Meredith may not be here to testify on Thursday. She may not be, not only not able, may not be able at all. I was there waiting for the primary physician. I called your office with about a half hour left before court. I could have made it here in time, left my number just so that I could get the advice from the court. But I tried to get.
I'm not so sure why that couldn't have been done over the 3-day weekend.
Because the primary care physician wasn't there, Your Honor.
Mhm.
I can't, I have no say in his schedule. But I did go in this morning. He actually, last I checked, he was writing it after I left because he was with a patient. That's what I was waiting for. But he went ahead and wrote the letter that you required. And I also asked that he leave a contact so that Your Honor could go ahead and contact him directly. But her situation has apparently gotten critical. She may not be here till Thursday. Be here on Thursday or Friday when she would be potentially testifying. If Your Honor would look at the motion, it's explained.
Well, okay, that's not my first priority. I'm not sure what motion you're referring to. Well, what is the nature of the motion? What relief are you asking for?
Your Honor, that's exactly what I was just explaining. She's critical. She may not live.
But you explained her condition, but you didn't explain the relief that you're.
No, the relief's in the motion, Your Honor. But what it is really all I'm trying to do is accelerate the Zoom hearing that we talked about and be able to hold it immediately today, as opposed to putting it off till Thursday or Friday.
Yeah, I'm not going to address that right now. We'll get to it. Right now, I'm going to address what I said I was, and that is the discovery or the impeachment material.
Yes, sir.
So, did you get the impeachment material that you were intending to use in order to provide?
Yes, sir.
Okay. So, State, have you received materials from the defendant?
Judge, we have the materials. Again, my objection is the defendant said any or all of this 2-hour-long IA interview. And again, I'm asking for what portion, what's the inconsistency he's going to impeach, and what portion of that interview is he going to use to impeach it?
So, Mr. Tucker?
Your Honor, it's impossible for me to say exactly everything I'm going to try and impeach when I haven't finished with my questioning yet. There's no way I could tell him that. I mean, if she doesn't say something inconsistent, then I can't use it. I mean, it's that simple. I can't exactly say all I'm going to use, but I did limit myself, which I don't think I had to, but I limited myself to those things that I gave to the State.
Well, it's most extraordinary that someone would think that out of a couple hour, or however long it is, tape, that it would be virtually all potential impeachment. I mean, attorneys are expected to be able to provide the opposite side with as specific notice as possible of what they intend to use or believe is impeachment. So
I did do that, Your Honor. I just didn't point to specifics in each testimony, which I don't think the State's going to do either.
So how would you gentlemen like to proceed? I mean, I remember speaking on Friday that you almost anticipated that I would have to view the entire thing. And so that's one of the reasons we're here and put the jurors off until 1 o'clock.
Yes, sir. Judge, let me just apprise the court. The defendant emailed us Saturday morning at noon, which was the deadline, and he said, I plan on using as follows: interview room tapes 1 and 2, IA tape multiple sections. And again, I would ask, we're not going to sit and play a 2-hour IA tape. So I would just ask for what's the inconsistency and what portion of the IA tape. I mean, our witness is coming back in today. We're in the middle of cross-examination. We're going to pick up with where? You know, where do we start? Is he going to try to impeach her right off the bat? Is he going to begin questioning her? Is there already something he feels that he has the right to impeach her on? I'm just not clear where we pick up from today.
Yeah, I mean, Mr.
Your-
Tucker,
Your Honor,
when the witness is coming, you have to be able to cue this up and present it. We're not going to have what we had on Friday. We're not going to, that's
no, I understand, Your Honor.
people back and forth and waiting anymore. So you have to be able to identify what it is you intend to use.
Your Honor, I have identified exactly what I intend to use, and the state should be well aware of all of that evidence since it came from them. So they should have already examined it. They should already know what is potential impeachment material. Just like they don't tell me exactly what they're going to use. They just tell me which exhibits they have.
Well, sir, simply because something's provided in discovery doesn't make it admissible, nor does it mean the state's committed it to memory, nor does it mean it constitutes valid impeachment material. So
I understand that, Your Honor, but I don't know what I'm going to use until I'm finished my questioning, Your Honor.
okay, well, let's start with the first part. I mean, again, if I have to sit here and watch the whole thing, so be it. But we're not going to have a situation where these jurors are made to wait because
I have no problem with that, Your Honor. You know, I have absolutely no problem with that. I have a flash drive that, that was part of the problem, is just the interface with the technology. I can't exactly plug my laptop in there. I found that out on Friday. Okay, so now that part I have no problem with. I also have no problem with using any of this impeachment material and definitely saying how I'm using it while I'm in the process of questioning the witness. I assume that is customary usually.
no,
right?
this is completely not customary.
No, I mean, it's customary to ask a question if she makes a misstatement, or if she, for lack of a better word, lies, then that's when I bring out a tape.
Okay, well, again,
But I often do that.
again, I got to, what else are we going to do other than to see the thing? And so that's what we're here for. So let's,
I mean, if you would like an example, I could give you one.
no, I don't want a kind of sort of maybe, I want to see this and make rulings, because otherwise I don't see where we've made 1 inch of progress from
Your
Friday
Honor,
afternoon.
if I may,
Yes, sir.
while I am not an attorney, and we've all made that clear, the thing is, okay, the state is not going to tell me anything of any of the evidence that they plan on bringing in until they bring it in, right? They're not, they give it to me the same way. They give it to me in bulk, and I have to go through it and decide what I think they're going to use. Well, I imagine they're the same way.
No, sir. Have you ever seen a prosecutor in 27 plus years of doing this that, doesn't have a very clear idea and presents it clearly? Yeah, sometimes there might be some little snippet or something, but not where there's apparently hours of tapes that they
Well,
are
because
using, frankly,
okay,
very inartfully.
okay, I'll tell you exactly one that I plan on using, and it's the hours-long tapes that they're talking about. There's 2 of them, the interview room tapes.
Mhm.
Those I'm using to impeach the fact that she said specifically that I wasn't named a suspect till the 22nd, and I was named a suspect because of the testimony of John Travis Johnson and Rory Wilson. Those 2 hours worth of tapes, that's all they're discussing is me
Well,
being a
we're
suspect.
not going to have that. I mean, you can show me, but we're not going to have 2 hours worth of tapes that somehow or other impeaches a minor point. So,
No, and I would actually fast forward. I do have the timestamps. I can fast forward to each section that applies to that witness.
okay, well, let's do it then.
Well, Your Honor, if I might, I'm definitely willing to do that. I'd still like to address the other issue.
I'm not going to address it. I will address it when I'm ready to address it.
No, I was just.
This is this session, Mr. Tucker, you're starting to stray from the basic parameters here. I set this session for this issue, and that's what I'm going to deal with. And if Ms. Belmonte is unable to, we will deal with it, but if she's unable to testify, then we have these deposition to preserve testimony. But one way or the other, I will deal with this once I deal with the issue that I've set.
Okay,
So
I'll tell you what, I'll just play the tapes.
This judge is very biased. He is an a-hole. He's all nice to the state. The state, anyways, it seems he don't like people pro se. I hope the jury sees how this judge is being to this man. It's under his control if someone's really sick and cannot make it. He has no control when a doctor writes a report. Unreal. So Ty is doing the best as he can, in my opinion. I'm going to keep track of how many objections and when that judge yells at him. And I think he handles himself pretty good. There's something they're doing on purpose here to him. So, yeah. I don't know what they're waiting for. Hope everybody had a nice 3-day weekend. I didn't do anything. Hold on here. No. There I am. I'm way up there. See that?
This is why I'm trying to do this now, so we don't have this sort of delay.
You have to forgive me, Your Honor. I was concentrating on Miss Belmont.
You don't need to rush. Let him take his time, Mr. Impatient Judge. I'm going to call him biased, and I got to come up with a name for the state. I would be really respectful, but look at their behavior. I hope the jury just sees through it. Just saying.
So I don't, no, I don't operate that equipment. You're saying that you need the assistance of Terry, is that what you're saying?
I've asked her only because I don't want to mess with her.
Well, Judge, why didn't you have that taken care of before the hearing today?
Let's see if he's here.
Huh, Judge?
I just don't want to take a chance on
And no, I'm not going to be nice today. I'm going to say whatever on my mind. Here, this man's freedom is at stake. They want to see him fail. It should be a fair trial.
Is he available? Yes. Thank you.
They already think he's guilty. What's wrong with this country? Their sound still sucks.
Doesn't matter to me. I mean, I
Wow.
said I would, I mean, there's cannot imagine that
All right.
there is
Here's my
some
calculator.
specific portions of a couple hours that can't be honed in on, but be that as it may. Well, that would be hearsay. That would, I mean, there, you know, if there's some statement that was made, that's one thing, but a discussion between various parties is not impeachment, sir.
You did not know that the investigation, I was on October 22nd, you had a couple hour long conversation about it on the 20th. That isn't.
Well, sir, you can claim it is, and I make the decisions, and it might be admissible in some form and not the other, but you think you're going to, anyway, but you're,
Yes.
yeah, good, I hope so. No, sir, you don't need to placate me, just do the business. I'm tired of all the extra fluff. Do what you claim you're going to do, otherwise you're not going to be able to, so.
I object.
Which should have had arranged. Again, if an attorney did this, it wouldn't even be close. I wouldn't have put up with it. I'm bending over backwards, trying to facilitate you who doesn't really know what you're doing, and that's not a surprise, but you have the right to represent yourself. You don't have a right to delay things or to attempt to, you can attempt to, but to admit things that aren't admissible. So in any event, this gentleman now needs one more time some assistance in operating the equipment. Could you give me a hand, please?
It wasn't working on Friday. Why didn't you have it fixed, Judge? Hi, Dan. How you doing? The VP stream with Brenda. Yes. And if anybody thinks that's okay, I don't even know what to say. Okay, so far, he's been rude and yelling at him 8 times. I'm keeping track. Oh, thank you. I appreciate you.
Sorry, I can't, could you apply?
Here he goes again. That's right. Okay, Judge, I got you.
No, apparently apparently the court reporter has a question. What-
wanted to know if it was a video or an audio only.
This one is all, actually, all, the other one, it's only on, interrogation.
I think they're doing this on purpose.
This interview is being conducted in the Monroe County Sheriff's Office. It's the Sheriff's Conference Room. It's taking place on May 2020 at approximately 13.
Good. Tell me when you get to the part that you want to use, because all of this would not be. No, no.
Regard to what's commonly known as it took place on November 17th.
To me, they are somehow violating his rights
Investigation regarding the management
or on the borderline.
of the investigation.
All that stuff is inadmissible.
What? Why is he doing that? You hear that? Oh, I hope they fix that. Dan, I have a problem with the judge. This is a witch hunt for that man. Okay, Court TV. Go fix your cameras. Wow. We can't watch a trial like this.
It is not.
That's all hearsay.
Well, I mean, I understand, but this is apparently the first part that he actually wants to use, where she said his name first came up with the Metro PCS stuff, and I could have swore she testified.
Exactly what you testified to.
Sir, she testified to that. That is not It's not impeachment. That she said that.
Also living with Hillary, and then he got solidified as a suspect.
If you guys want to sit over here in the jury box or wherever.
Honestly, his interview and John Travis Johnson's interview.
His interview being covered.
Yeah, being covered.
How did that?
Well, some of the things that he said that they all used, John Travis Johnson as they were with him going to buy cigarettes at some point during that night. So they were with him all
Yeah.
of them went.
That's also brings up my point. I haven't asked him these questions. Right? So I don't know this yet. And now I'm coming to the state. They could have, again, talked to the witness, whatever, but I mean, if they know what, if they know what the potential of impeachment material and use are exact.
And again, I'm familiar with this interview. I understand what you're saying. My specific question is, what does the inconsistency that she claims she
say what the answer can be my questions? No. So how do I tell you?
When we broke on Friday, Judge, we were right in the middle of, he was attempting to impeach her.
One question. Right, one. Not all, one.
Well, okay, in any event, you know,
Should I let, keep playing if you want. It's just, it's, again, the witnesses. Keep going.
themselves together, and they're trying to distance themselves from the crime.
Did the video, I know you mentioned video from the motorcycle place, or any other video establish the identities of your suspects?
Yes, the video from the Marine place, I didn't feel like me, I don't remember what the name of it is, but it's right next door to,
Cosmos, or,
okay, yeah, that video.
yeah.
It's right next door to the tree house. When we finally got access to that, we could see on the video a dark colored truck circle the tree house. Then there's a break, and then the dark colored truck comes back, parks almost right in front of Cosmos, whatever, the Marine place. And you see two people walking away from the truck, and based on the way the ones up there walking, everything about him is built because of how big he was, that was gonna be Detroit. And then the other one, his body type and everything matched. Franklin Terrell.
so, I'm sorry, we can't speak over one another. I'm asking, where's the impeachment? If that's supposed to be impeachment,
Everything that he told us.
This is now, again, an hour long, maybe an hour long. Hold on, I can tell you in a second. This is how long tape. She actually has asked about this more than once. And okay, just in this one alone, she says, yes, you know, this verifies it, this tape verifies this, which we established at length on Friday, but no, it doesn't.
and she said as much. She said,
She did eventually.
We stopped the tape right where she says, Travis Johnston, this, what we see in the video matches up with what Travis Johnston told.
she readily acknowledged that she can't see faces. She puts things together. This is a piece of the puzzle, sir. So if you think, Mr. Tucker, once again, you are deteriorating into interrupting. She doesn't say she can now see the faces. She is putting the evidence together. So there's no impeachment there. Yes, sir.
I don't need to interrupt.
Well, you
But I
do
don't-
constantly.
Well, I was trying to
But
tell you, there's
we
no-
take our turns, and you don't seem to get that. We talk one at a time because it's polite, it's a way to communicate, and it's the way the court reporter can get the information in the record. So in any event.
I understand.
Okay, sir.
But it doesn't feel like you're listening to me.
Oh, I'm listening very much. It doesn't feel like you're listening to me, but be that as it may, that ain't impeachment.
No,
So-
so far it's not. You're correct, Your Honor. But I also said, there is additional in this case. It's not the only time they bring this up.
Well, okay, let's hear it, because trying to avoid the jury being, delayed.
I understand.
Matched up to the video. That he used to get away from her, that he took off, because he got kicked out, and all of that matched up. So,
Okay, was there any other video? I know there's mention in the reports here somewhere, some video talked about.
There's a video of the outside of Tom Thumb, it's not actually Tom Thumb's video.
Oh, okay.
Tom Thumb, we attempted to get the video. They gave us the video as the wrong day, and then we just never could. Every time we tried to get video from him, it just it didn't work out.
Did, say the night of the incident, I know things go crazy. There's no doubt about that, but do you know if any detective, any road patrol deputy did go to Tom Thumb, see if they could roll back their video?
Me personally, I don't know if anybody did. I'm sure they did, but I don't know if anybody did.
Now, there was another video, of two suckers walking toward what's called the warehouse where they live. Is it Third and Fourth, I believe? Yeah, Fourth, Third. Right, Tony's roof, that area.
Yeah.
That intersection. Did you see any of that?
Yes.
Questions?
Okay, what did you see on that?
Just two soldiers walking, I believe there was two, they were walking towards what would be Tom Thumb and or the tree house.
Your Honor, to clarify. There are sections of the, I haven't asked questions for yet. I don't know why about it. So I don't know whether or not there is another section in there that fast forward to that section. It's relevant to the question is on the table.
I believe the night of the search warrant, John Travis Johnson wasn't on our radar yet. We didn't have the video showing the getaway car. And nobody at the scene had mentioned, John Travis Johnson yet.
Okay.
Because we didn't know who was the so John wasn't on our radar whatsoever. Franklin Tyrone County was back on. Going to jail.
Okay.
We eventually get the video showing that there's a getaway driver.
Yeah, I looked it up. He's got 13 charges, and they're mainly for assault. And let me tell you something. Yeah, she's making poor decisions. She's spending money. That's part of mania. She's sleeping with strangers. She is, well, with a man, period. She is doing dangerous things. And let me tell you, the reason why I feel this way, because before I was diagnosed, I did those type of things. And there's that. So I see what's going on here. And I give her my 2 cents because of I like to help people. I've been doing it my whole life. Helping people, like let's say I used to speak at schools about teenage pregnancies because I had my first kid at 16. But some of the comments I seen, I couldn't believe it. They were victim shaming, addict shaming. More men stuck up for her than women. So I'm not going to judge her because you know what? She needs to get on the right medication. She has to go to a therapist. But she's on a downward spiral. I see it happening. Something bad has to happen in order for her to get the help that she needs. And she needs to stay off the internet. And there you have it.
I haven't asked the question yet, so there's no way to know if she's lying.
In any event, whatever, there's still a requirement that we move in a particular appropriate manner and not make jurors wait inappropriately. So I don't know how much more specific I can be, and in any event, I'll just leave it.
And I've heard you, and I'm trying to be as trying to accommodate for it anyway.
Well, we'll see.
See, the thing about it is, I wasn't mad at anybody. I was disappointing because these kind of things need to be talked about. No, people are still sweeping everything under the rug, and we're in 2024. I could see that 25 years ago, no, 30 years ago, but today, nobody wants to see it. Nobody wants to talk about it. Nobody wants to help. And there's that disappointment.
Investigation for exhibits by Colonel Chad Sevilla, Local County Sheriff's Office, that is the recommendation. And he goes on to this, any and all Local County Sheriff's Office, Division of Internal Affairs documents, recordings, any and all Local County Sheriff.
Their audio sucks.
Documents, recordings mentioned in the deposition, any and all criminal, civil records from civil lawsuits resulting in this case related to the police audit. Basically, you can do that under the evidence code, they are not relevant.
Okay, so let me start again. I think I've got I think I've got it up here.
Here goes the judge
Just
again.
trying to set the stage here that the state received supplemental discovery on January 12th. And so you're not even saying it's a discovery violation, you're just saying that it's a inadmissible?
I'm saying it's inadmissible, but I would just, I guess for keeping things simple, I'm going to claim the discovery violation. These are all obviously not related to the fact that in this case, they're allowed to matter of the civil nature.
Okay, so now, defense. Go ahead.
Your Honor, I did look at the evidence code, and I didn't know I have. As far as the piece where it is, every, all discovery was due for that, that was left in my previous attorneys. So that was actually, that's been in there for the entire time. Now that was, and I also imagine, yes, and what happened in the course of this trial, and that whether or not it's admissible depends on the circumstances. That's what I would imagine. Just like we're, yeah.
I was disappointed with the women. Okay? I'm not mad at nobody. I'm disappointed, and I just put it out there about my mental health. What do you mean? What? By the way, your mic is on. Yeah, I want to talk to you guys. Instead of me typing, you know, because all they're doing is yelling at Ty. And I'm keeping track.
All that, I don't know. It seems unlikely, but maybe there's some nugget in there that, could be admissible. It's really hard for me to say right now.
I think we understand where it's coming from. Our concern is this. I think we've already established Mr. Tucker's confusion that he's not going to do an hour IA interview and the jury's not going to hear it. This is IA investigator, blah, blah, blah. And I mean, that's an hour of hearsay. That is in irrelevance, other than if there's an inconsistent statement made on the stand and there's a specific portion that addresses that inconsistent statement. I would concede that might be admissible, but as we just heard, what Mr. Tucker is perceiving to be impeachment is not. And that's my concern is that, before the jury hears or sees anything, I want to know who's committed because I don't think there's impeachment in there. Certainly not so far. And before that's done, I'd like to hear what he's going to play to the jury before that attempt to impeachment.
I think that would be that. This all goes to the but I didn't, I know.
Look at how calm he talks. But then you have the judge.
A judge is preposterous to suggest that a truck somehow phantomly drives up.
we don't need to, I already made a ruling on that one, okay? All I'm saying is that proper procedure is for the proponent of the evidence to have it honed in to what they believe is admissible in impeachment, and to not just keep a jury waiting for an inordinate amount of time while we do something that we should have done before. As far as these materials that were listed as supplemental materials, again, I'm not going to just make a blanket ruling, but to the extent that if there is something that Mr. Tucker believes is admissible before it's offered, we should alert the state and the court, and we'll have to have a hearing outside the presence of the jury to determine whether it is admissible. So that's the court's ruling as to that. Okay, so now have you seen the defendant's motion about emergency motion for immediate appearance? Had you seen that? Okay, so did you want to be heard on that?
Yes, sir.
Go ahead.
As I told you, I gave my solutions in the motion, but Paula has taken the turn for worse. It's not expected that she can make it as long as get to the defense side of things. I did consult my advisors. They said that it's not uncommon for a witness to go out of order, but that I should alert the court of the circumstances. And yes, attempting to get the primary care physician's recommendation for you and his contact information to verify your charge.
Okay, so you haven't come up with anything in writing then?
I do have a review written notified Ms. Belmont. That's her wishes. The primary care physician notified the state someone contact report. But yes, the primary care physician, as far as I know, at this point, before I make a letter, so I'm not aware.
All right, so if I understand correctly, that even though we don't have the information documented that she is, to quote the motion, her health is at a critical point, and she, again, to quote the motion, could be eminently fatal. So I had agreed earlier that she could testify by Zoom at the defendant's case. Now they're asking that the evidence be taken out of order in the midst of the state's case. So that's,
And I would object to that, Judge. I wanted the court to be aware. She was posting all weekend back and forth with Mr. Tucker. Either one was posting. There were pictures of them together. She was complimenting him, what a great job he's doing. She was laughing at the fact that I raised an issue about him staring at us during the presentation. She announced at one point in one of the postings, I don't know who posted it, one of them, that she was going to be released today. And she reposted she'd be released today, but she wasn't going to have one of our people sitting in the room with her, as I had made the request last week. So she seemed to be posting fine all weekend long, and then this morning we're told that she's on her, her dying breath. So until Your Honor is able to get more information, I don't object it. I mean, we're in the middle of a witness right now. And the state hasn't even rested its case yet. So I don't know. This is the reason her testimony was preserved, because we were told she was on her deathbed 6 years ago. So her testimony was preserved. I can't envision why we would somehow rush this testimony in the middle of our case and let the defense present a witness in the middle of the state's case and somehow tell the jury that's not part of the state's case, table that information for the defense case. I just think it would be highly improper and extremely confusing to the jury.
right, defense?
Your Honor, first off, I am not aware of most of the postings that they're talking about because I haven't been paying attention to my Facebook. Yes, I did post a picture of Paula and I last night when I was in the hospital with her. And yes, they did inform me that in fact, she alerted me in the morning to her condition. I went to the hospital, the nurse was there, verify that yes, her condition is in that state, but I could not, I'm not a doctor. I wanted to know from her doctor for your honor, right? Because I knew that was going to be something you would want to see. And yes, I was there this morning. He wasn't there yesterday. I was there this morning trying to get that. And he is now apparently off of that. Now, the state may be mad about her posting whatever, but that doesn't tell you her health. It doesn't tell you that whether or not she's going to.
I'm not worried about her
I'm not a
posts.
doctor.
I'm not. I mean, in terms of this issue, if it's some other issue, I mean, I'm not worried about the post as far as that's concerned. Yes, sir.
Again, I know we have to preserve testimony, so do they. Now, again, I looked at Marcy's law, and yes, she has the right to testify at any hearing. The victim's rights are clear. And all it says is that we have to make, every accommodation, like reasonable accommodation is what it says, right? Now, reasonable accommodation, I think it would be more than reasonable here, right? If she is that ill, and if the doctor says that, then why can't?
Anything further? I'm hearing about Marcy's law now. I mean, it's kind of interesting because in 99% of the cases, the defendant would be not desirous of the witness, the alleged victim, being accommodated, quote unquote. In this case, is different, which is fine, but that's been brought up.
Judge, first of all, I'm not mad at anything. I want to clear that up. I'm just bringing to the court's attention information I have. I have a job to do, and I'm doing it. So I'm not mad about anything. She's not a state witness. She's not a good state witness. She's on our witness list. What she's going to testify to, we're already aware of it. It's in her preserved transcripts as well. But I don't think anything has been brought forward that would require this court to make those drastic accommodations at this point.
Anything else from the defense?
We've already admitted that it hasn't been brought forward yet, Your Honor, and yes, it is in the process.
All right, so here's what. I indicated that I would allow her to testify by Zoom from the hospital. I used my discretion. I could have said at that point, no, but I felt that that was the fair, best thing to do. But at this particular point in time, I'm not going to force the state to, have a witness, adverse witness, called out of order when we have a deposition to preserve. My discretion at that particular point would be to say, if she's unable to testify by Zoom, then she can be heard when it's the defense's turn with the deposition to preserve. That's why it was done. I'm not going to force the state to have a witness taken out of order. Yes, yeah. Mm-hmm.
If, again, this is an if, but if the doctor, if the primary care physician confirms what the defense is selling,
Yes.
And she is still wanting to testify, as is her right. Again, I mean, yes, we have, and to make it clear, in that motion, when we proposed her for that, we did the motion to perpetuate. It was on the condition that she would be unavailable, right? Unavailability, I looked up in the law too. Unavailability means we have made every reasonable accommodation, and she cannot be here.
Yes, sir.
I'm just asking, would Your Honor change his opinion if he has the doctor's note in his hand?
No, I don't believe that the state should be compelled to allow or to have a witness taken out of order when there's another way that witness is able to testify during the defense's case when they want to call her by the deposition. So at that point in time, my discretion is that the utilization of the deposition to preserve. Yes, sir. Well, you are, but maybe you don't think you're trying, but you are.
As the defense, the prosecution as well, and they argue themselves. There's a big difference between somebody giving live testimony and the video deposition. I do think it's highly prejudicial to this case. It's highly prejudicial to the defendant. It is highly prejudicial to our case if that witness is allowed to, again, succumb to succumb to fatal injuries and not be allowed to testify. I also think it does go right against Marcia's law. Because she is allowed to testify at any hearing.
Yes, sir. I understand what you think, and I think otherwise. So that's why the deposition to perpetuate, I was told years ago, we need this, Judge. We got to move, we got to get this done. And lo and behold, now perhaps it's going to be necessary. I was willing to allow her to testify by Zoom. In your case, where I draw the line is to force your opponent to have their case interrupted by this testimony when it can be presented during your case, albeit by deposition to perpetuate. So irrespective of what the medical opinion is, the court's not going to allow this witness to be taken out of order. So that's.
I don't know if I'm wrong. I may very well be, but I was also informed by my advisors who are my attorneys that this is not uncommon, that it is not uncommon to go out of order, that sometimes it's even done for things as such as vacation, much less somebody who may not be around to testify.
It happens. It's true. It does happen. That doesn't mean. I understand what you can't see. I'm not going to force the state, oh, guys, you got to stop right here. You've got to let Mr. Tucker present a star witness right in the middle of your case when we've got a deposition perpetuate. I don't think that's fair, and I think there's another way that you can get that testimony here. That's my decision, and, that's how I see it. So, and unless there's something else, we have more materials to review, or
Judge, at this point in time, we have a witness coming in at noon. I guess the jury will be here at 1. Again, Mr. Tucker said that he's got other impeachment, but he doesn't know if he's going to use it or not. Again, the court's already made this clear that impeachment is a specific area. It's not a 2-hour tape. And I guess we'll have to wait and see what happens as the witness is testifying and see what Mr. Tucker's trying to use to impeach.
okay, I've done everything I can to try to make it as smooth as possible. We expect any other witnesses this afternoon, or?
That's the only one we figured by the time the cross is done and we correct it, it's hard to have anybody else really here at that point, because we don't know timing. Maybe it would be prudent to have the court hear this IA interview that you keep referring to.
That's not a.
Not the IA, the light tape or whatever that is.
It's 2 hours worth of tape.
Again,
Yeah, I can't tell you specifically what I'm using.
Okay.
But she has a second.
All right, well, then, it's pointless then, other than to expect the defense to be able to at least cue in on that part that they believe is impeachment. That's all I can ask, is that you have the,
You're on, I'll make sure.
okay, so,
I think that's it, Judge, for now.
okay, we'll see you at 1 o'clock, or maybe 12:55.
So, are they going to be on break until 1 o'clock? You know what? And the judge makes me mad. You want to know why? Because at noon, they were all done with court. Because the state was having an issue with what he wanted to present, that hot mic. That's okay. I got it out there. Oh my God, I don't feel good. Oh. Yeah, my thoughts are being really weird, and yeah, I know the words, but they don't come out right. Let me go see if hold on. If Court TV or whatchamacallit, I can't even think. Oh my God. Hold on. I'm going to Law and Crime, see what they say. Law and Crime. Oh my God. Wow. Nobody's covering this trial. Kind of shocked. Oh my God. All right. Okay. The jury is not coming in until 1 p.m. Well, that would be Eastern for your side. So let's see. One. Can't even think. Wow. So that'll be noon my time. Okay, so I'm going to go for now, and I will be back like 12:15. I'm going to go do what I need to do. Grandma, I'll call you later. I got to call my insurance company and have them authorize it, pre-authorize, and to see which ones they're going to cover. I want to thank you and Dad for being in here. I appreciate you. You know that. But I'll come back. I'll come back. Okay. Love you, Grandma.